Before we even step into this courtroom, you need to understand something. This is not just another case. This is what happens when someone believes they can outsmart the legal system by refusing to play by its rules. Today's defendant, Thomas Styron, isn't just challenging the charges against him, he's challenging the very identity the court recognizes him by. And that might sound clever at first, but in a courtroom, that kind of strategy can backfire fast. As this unfolds, you're going to see a judge who is calm, controlled, but absolutely unwilling to tolerate games. And on the other side, a defendant who refuses to answer simple questions, rejects legal counsel, and pushes the limits of courtroom patience. The tension here isn't just about the charges, it's about control. Who controls the narrative? Who controls the courtroom? And here's the real hook. How far can someone push a judge before consequences hit? Because trust me, in this case, they hit hard and they hit fast.
Case People versus Thomas Styron. Here we go.
The public defender Otatella on behalf of Mr. Styron, who stands to my left. Well, let's talk to the judge about that. Right?
We've been through this. Seems to be some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
So, I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. Court calls the case of the People versus Styron. Recall. State your name.
my name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back. Maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Recalls the case, People of the State of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. And I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor, punishable by up to 2 years incarceration and or a $2,000 fine plus court costs. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through with the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Steyer so that he has some discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes, sir.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So first of all, watch your
language. You're treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a Sest QVA trust matter involved in this? Is my Social Security number attached to this at all? Go figure.
Mr. Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to compel me to be somebody I'm not.
Or this institution.
You have no evidence
It will not
to prove
happen.
that I'm who you say I am.
You will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
What you just witnessed isn't just a courtroom exchange. It's a clear example of what happens when someone confuses internet theories with real law. In People versus Thomas Styron, the defendant didn't just challenge the charges. He challenged his own identity, refusing to acknowledge the name tied to the case. At first glance, that might sound like a clever loophole, But inside a courtroom, that strategy falls apart almost immediately. From the very beginning, the judge made it clear. This court runs on structure, rules, and accountability. When simple questions were asked, all that was required were simple answers. Instead, the defendant chose deflection, argument, and disruption. And that's where things started to go wrong. Because in court, it's not about how strongly you believe something. It's about whether your argument has legal standing. And this one didn't. What escalated the situation wasn't just the legal misunderstanding, it was the attitude. Laughing, interrupting, and refusing to cooperate might feel like taking control, but in reality, it does the opposite. It hands control right back to the judge. And here, the consequences came fast. A contempt warning, followed by a 30-day sentence. Not for the charges, but for the behavior. The judge even gave multiple chances, offering legal counsel, explaining the risks of self-representation, and laying out the seriousness of the charges. But when those warnings are ignored, the courtroom doesn't slow down to accommodate. It moves forward without you. And that's exactly what happened here. In the end, this case isn't about identity tricks or legal loopholes. It's about a simple truth. The courtroom is not the place for games. You can challenge the system, but you still have to follow its rules. And when you don't, the system responds firmly, quickly, and with real consequences.